My understanding is that there are multiple copies available of the book, the Law of Article 5. Is that right? Okay. What many states have done, 14 states, is that they've adopted laws that provide penalties to any convention commissioner who exceeds his or her power. I believe Indiana might have been the first state to adopt that. That is an additional way. It's kind of a belt and suspenders. We've already got the suspenders. This adds the belt to make sure that commissioners stay within the scope of their power. One of my written products on Article 5 conventions is a legal treatise called The Law of Article 5. It's a short read, and I guess there are about 40 copies of it available. At the end of the book, The Law of Article 5, you will see a sample runaway act. It's called the Uniform Interstate Conventions Act. And what it does is it balances the legal issues in such a way as to maximize the enforceability of such a law. There's some aspects of some laws that may not be enforceable. The bottom line here is that if after everything I've said, you want that additional suspender, that 75th suspender on top of the belt and the 74 you've already got, then you could adopt a delegate, a no runaway law, which punishes delegates who attempt to exceed their authority.
Yeah, I know that there were a number of states. I think I don't know if you know how many states we're up to now that have done
14.
14. And so effectively that would limit the amount that would be necessary to defeat any type of a convention going astray. You would need 13 essentially to block any type of untoward activity at a convention, would you not? And so having 14, does that not put you over that limit anyway?
Well, you mean, are you talking about ratification?
Right. Well, I'm sorry. Yeah, I'm going a different direction.
The convention operates by a majority vote unless the convention decides otherwise. So you would need 26. But again, you've already got the ruling out of order provision, and you've already got the come home orders and so forth. Yeah. However, if by some way, and I don't know how this would happen, I think it's roughly equivalent to the sun coming up in the west, unless you happen to be on Neptune, where it does come up in the west. If somehow an unauthorized amendment came out of the convention, and if Congress nevertheless appointed a mode of ratification for it, which it could deny if the amendment were unauthorized, then 13 states could block the amendment. If the ratification is by state legislature, that just means 13 houses out of the 99 houses we've got could block the amendment. The real risk, let me tell you frankly, the real risk of regarding the proposal process, the convention process, the real risk is not that the convention is going to do too much. That risk is like zero. The real risk is it's not going to do enough, that it's not going to respond to the situation as David Walker has outlined it. Now, that doesn't mean we shouldn't try, but it means that the talking about the risk of it doing too much is completely the wrong discussion. The discussion is, how can we get the convention to propose an amendment that has teeth? And secondly, how can we get 38 states to ratify it? I think it's doable, but it's going to be tough.
And so, I mean, I guess the point is there are so many controls that you have as a legislative body in how you choose your delegates, how you control your delegates, how you limit your delegates to a convention. In the materials that are part of the conference materials, you have a number of examples of these no runaway ratification and delegate selection and recall types of laws. And again, if you have any questions going forward, you have the panelists and others to draw upon with questions that you may have as you're working in your legislative bodies.